Attorney-General for Northern Ireland.
Yes, Mr. Attorney.
My Lady, the Lords, I appear, my other friend Mr McLean and Mr McLaughlin appear for the Advocate General, and Mr Jones, Mr Honey appear for the A5 Alternative Alliance, the interveners. My Lady, my Lords, subject to the Court, I propose to break these submissions down into three parts. Firstly, I'll look at the questions and the provisions to which they relate. Secondly, I'll look at the extent to which those questions are embraced by paragraph 1D of Schedule 10 to the Northern Ireland Act 1998, and that will of course require us to look at the intervener's case, that they are not so embraced and that they do not arise under this Act. And thirdly, I'll look at the intervener's arguments that the existence of the Court of Appeal decision in Buick prevents this reference, as also, alternatively, from their perspective, does a suggested overlap with the A5 case, at least as respects questions 3 and 5. Obviously, I adopt the contents of my first case, that's MS 86 to MS 100, and of the supplementary case, MS 139 to MS 146. By way of preface to those three parts, I should attempt a quick snapshot of the current constitutional landscape in Northern Ireland. There is an assembly, but it doesn't function. We have no ministers, no executive committee, no programme for government, but we do have departments. We also now have Section 3 of the Northern Ireland Executive Formation and Exercise of Functions Act 2018. That's at tab 18, MS 859. And I make two quick points about that Act, about Section 3 in particular. Firstly, it leaves open by Section 3, subsection 8, whether subsections 1 to 7 were or are necessary. And secondly, Section 3 is time limited in its effect to the period for executive formation.
What provision are you referring to?
Looking at Section 3.8, that's at MS 859.
Yes.
And simply making the point, my Lady, my Lords, that Section 3, subsection 8 leaves open the issue of whether subsections 1 to 7 are necessary. And our second point about Section 3 is that it's time limited to the period for executive formation, and that's defined in Section 1, subsection 5 of the Act, MS 858, as having a backstop of when the current Assembly, that's the Assembly elected on the 2nd of March last year, is dissolved.
But it can be extended, can it? No?
It can be.
Yeah.
Turning then to the first part of these submissions and the questions before the Court. They are in the preliminary hearing bundle at MS 86 and MS 87. And if I perhaps simply let the Court look at that, let the members of the Court look at that themselves, I simply give a quick gloss. The first question essentially seeks to know if the Northern Ireland Ministerial Code applies to departments or if the code just applies to ministers. And the second question seeks to know whether the loss of authority described in Section 28A10 of the Northern Ireland Act as ministerial applies to departments as well as ministers. And as for the third question, it essentially asks when the obligation introduced by Section 20, subsection 4A of the 98 Act applies. Does it apply only if there is such a programme in existence. As for the fourth question, this question in many ways is linked to question 3. Section 24 speaks of the function of the Executive Committee, and Section 28A5 speaks of ministerial code provision requiring ministers to bring to the attention of the Executive Committee any matter that ought, by virtue of Section 23 or 4, to be considered by the Committee. And the fifth question asks, what is the effect of the ministerial code provision required to be made under Section 28A5 on departments? Does it act as a limitation on the power of departments or just on the power of ministers? Clearly, these 5 questions explore the meaning of 2 important provisions of the Northern Ireland Act, Section 20 and Section 28A. And Section 20, subsection 4, is filled out by paragraph 20 of Strand 1 of the Belfast Agreement, and the Ministerial Code contains provisions that are required by Section 28A5. All of these questions arise in whole or in part from provisions that were not in the Northern Ireland Act when it was first enacted, but were inserted following and as a result of the St Andrews Agreement. And I'll take the Court quickly to the St Andrews Agreement. It's at Volume 2, Tab 11, MS 727 and 728. Paragraph 2 of the Annex, containing practical changes to the operation of the institutions, provides that there will be a statutory ministerial code and placing a duty on ministers, including junior ministers, notwithstanding their executive authority in their areas of responsibility as defined in the agreement, to act in accordance with the provisions on ministerial accountability of the code. 3. The 1998 Act would be amended to require inclusion in the Code of agreed provisions in relation to ministerial accountability, consistent with paragraphs 19 and 20 of the agreement. This would provide for the Executive to be a forum for, and then there are a range of matters which are to be included. And then importantly for this case, paragraph 4, the Code will also provide for the discussion of an agreement on any issue which is significant or controversial and clearly outside the scope of the agreed programme for government.
Is it your case, Mr. Attorney, that it's open to you to refer questions to this court which are purely academic?
It would be, but these are not academic questions.
Well, we'll come to the second in a moment. You say that if you come across an interesting theoretical question which hasn't arisen in proceedings at all, it's open to you to have recourse to your powers to refer that question to this court.
If it arises under this Act, and of course I make the distinction straight away between that which is possible and that which is desirable or proper. So,
well, what's the significance of that distinction?
Well, any power or duty is capable of being used badly or being, in fact, straightforwardly abused. But nonetheless, its exercise is legally possible.
Well, what's the significance of the words you just said, if it arises under this Act?
Well,
what was that condition?
Well, the distinction, it seems to me, my Lord, relates to if one has, for example, my Lord Kerr referred to an abstract academic question. So let's say, for example, one knows that peerages, titles of honour, are accepted. So it wouldn't be open to the Northern Ireland Assembly to create its own system of peerages. If one simply were to ask, was it right for Mr. X to be ennobled? That's a question which, although it relates to an accepted matter, couldn't be said to arise under this Act. In distinction, these are questions about provisions of this Act, and they cannot, in my respectful submission, be other than arising.
Well, in other words, you're treating arising out of the Act as synonymous with a question that suggests itself by a consideration of the terms of the Act.
No, because it wouldn't be as broad or as diffuse as that. If I'm asking, and I am asking, what exactly does the obligation in section 28A5 mean? Does it apply to departments as well as ministers? That being a question about the Act, it seems to me, can only arise by virtue of, or under this Act, the Scottish analogous provision uses by virtue of, but it seems to me, respectfully, to amount to essentially the same thing.
That particular question was answered by Mrs. Justice Keegan, wasn't it?
The question of
whether Section 28A can apply to civil servants as well as to ministers.
Yes, she answered it very firmly, and ultimately, in my respectful submission, she answered it correctly that it didn't apply, that the obligation to bring matters to the Executive Committee did not apply to departments, it applied to ministers.
So you didn't refer the question to this court in those proceedings. There's been no appeal against her decision. You tell us that she answered it correctly. So
there was an appeal.
Well, non-successful appeal.
Well, no, there was a successful appeal against her decision. The department appealed.
No, I meant not to this court.
No, there was no appeal to this court. Now, of course, chronology is important because the judgment of the Court of Appeal was delivered in July. This court did not deliver its judgment in Ashers until October. Now, it would have been a bold move, I put it no higher than that, to have acted in the teeth of the approach of the Court of Appeal and attempted to refer the questions in the light of the Court of Appeal judgment.
Yes, but there could have been an application for permission to appeal.
Yes, there could, but of course, my entitlement to play a role in the proceedings before the Court of Appeal is confined to the devolution issue. It's not confined, for example, doesn't relate to the Article 4 of the Department's Order. That's not, in fact, it's useful perhaps to refer to that because Article 4 is a transferred matter. A question about Article 4 of the Department's Order wouldn't be a question about a reserved or accepted matter. And the Department did not appeal. Now, in those circumstances, it seems to me, subject of course to the issue now being clarified by the decision of this court in Ashers, to leave the successful planning objectors in Buick with the fruits of their victory, but to explore the fundamental constitutional questions that the decision of the Court of Appeal has thrown up. So I was going then to take the court to the provisions of the Northern Ireland Act. So section 20 is at MS 386 going on to 387 within tab 7. And the Executive Committee is created by subsection 1. The responsibility of chairing the committee is given to the First Minister and Deputy First Minister. And then there is a somewhat unusual drafting approach that the committee shall have the functions set out in paragraphs 19 and 20 of Strand 1 of the Belfast Agreement. So rather than set out in the text of the Act, the drafter refers the reader to paragraphs 19 and 20 of Strand 1. And then 4, which is introduced following the St Andrews Agreement in 2006. The committee shall also have the function of discussing and agreeing upon significant or controversial matters that are clearly outside the scope of the agreed programme referred to in paragraph 20 of Strand 1 of that agreement.
That's a provision about which you ask a question. Your question 4 is, does the function in section 24A exist when there's no programme as referred to in paragraph 20 of Strand 1?
Yes, my Lord.
There's no committee, you've told us.
Yes, my Lord.
So, I mean, this looks like a completely academic question.
Well, it's not, my Lord, because the effect of the interpretation of the Court of Appeal is to prevent decisions being taken by departments. If there is a decision which is significant or controversial, it can't be taken because there is no executive committee. So the Court of Appeal has held. And further, the Court of Appeal holds that the effect of subsection 4 exists even when there is no programme that is referred to in paragraph 20 of Strand 1. So that we say respectfully, and this trespasses into the substantive argument. That seems to us to be incorrect, that one cannot be outside X if X doesn't exist. It's put, we would say, beyond argument by the addition of clearly. One can't be clearly outside X if X doesn't exist. So can we look at, so that we can see how the functions are described in detail in Strand 1. Paragraphs 19 and 20 of Strand 1 are at the beginning, tab 1 of the authorities, MS 278 going over to 279. And of course, I make the obvious point in relation to this document. This is a political document, which is why it might be thought of as unusual that the drafter has incorporated it by reference, because it's not drafted in a way that a statute would be drafted. So, paragraph 19, the Executive Committee will provide a forum for the discussion of an agreement on issues which cut across the responsibilities of 2 or more ministers, for prioritising executive and legislative proposals, and for recommending a common position where necessary. 20, at MS 279, the Executive Committee will seek to agree each year and review as necessary a programme incorporating an agreed budget linked to policies and programmes subject to approval by the Assembly after scrutiny in Assembly Committee on a cross-community basis. And if one can then look at section 28A, tab 7, MS 401 going to 402. And the court will obviously consider all of this, but the 3 subsections to which I wish to draw particular attention are subsections 1, subsection 5 and subsection 10. So one has the creation in subsection 1 of a duty, a legal duty to act in accordance with the ministerial code. A minister or junior minister shall act in accordance with the provisions of the ministerial code. Subsection 5, the Ministerial Code must include provision for requiring ministers or junior ministers to bring to the attention of the Executive Committee any matter that ought by virtue of Section 23 or 4 to be considered by the Committee. And the relevant provision of the Ministerial Code giving effect to the obligation in Section 28A5 is paragraph 2.4, Roman 5, and the Court will find that at tab 2, MS 313. 2.4, any matter which is significant or controversial and is clearly outside the scope of the agreed programme referred to in paragraph 20 of strand 1 of the agreement shall be brought to the attention of the Executive Committee by the responsible minister to be considered by the committee. So, from the St Andrews Agreement, one has the creation of a new legally enforceable ministerial code. One has the, in addition to the original components of Section 20, subsection 3, giving the functions of the Executive Committee, one has a new function that if there is, on our argument, a programme for government, then anything which is significant or controversial outside it must be brought by a minister to the committee for discussion and agreement. And the question then is, does that A, apply to ministers when there is no programme for government, and B, even if it applies to ministers, does it apply to departments? So that takes us to the second section of the submissions. Are these questions devolution issues? And a devolution issue is defined in paragraph 1 of Schedule 10 to the Northern Ireland Act. That's at tab 7 and MS 595. And 1D, devolution issue means any question arising under this Act about accepted or reserved matters. So that the Court has it, can I simply draw attention to the equivalent provision in the Scotland Act? It's Schedule 6 of the Scotland Act, and that's at MS 668. And that's 1F of paragraph 1F of Schedule 6. Any other question about whether a function is exercisable within devolved competence or in as regards Scotland, and any other question arising by virtue of this Act about reserved matters. Now, in approaching the question of what's meant by paragraph 1D, it's important to bear in mind that the meaning doesn't alter depending on how the power is invoked. So the meaning is the same whether a devolution issue is raised, referred to this court under paragraph 34. The Court of Appeal presents a devolution issue under paragraph 33, or indeed whether a courts independently raise the issue themselves under paragraphs 7 to 9. But it's my respectful submission that the schedule and indeed the Act as a whole must be read harmoniously and coherently. And if one looks at paragraph 5, MS 597, if a devolution issue is identified, a court or tribunal shall order notice of any devolution issue which arises in any proceedings before it to be given to the Advocate General for Northern Ireland and the Attorney General for Northern Ireland, unless the person to whom the notice would be given is a party to the proceedings. So if either law officer is already a party to the proceedings, paragraph 5 doesn't bite, but if they're not, then it does. So it's the court's responsibility, doubtless assisted by the parties at that stage in the litigation, to identify the devolution issue and to give notice. And then one sees that in paragraph 6, the person whom notice is given pursuant to paragraph 5 may take part as a party in the proceedings so far as they relate to a devolution issue. And that will be relevant, as we should see, for the third part of these submissions in terms of the question of whether devolution issues either were live at the time this reference was made. Now, as the court knows, the structure of devolution in Northern Ireland is complex as respects legislative competence, and we have 3 categories: accepted, reserved and transferred. Can I ask the court to look at section 4, subsection 1 of the Northern Ireland Act? It's at MS 355. Section 4.1, in this Act, accepted matter means any matter falling within a description specified in Schedule 2. Reserved matter means any matter falling within a description specified in Schedule 3. And then transferred is any matter which is not accepted or reserved. And then there's provision, powers given to the Secretary of State to move matters between the categories of transferred and reserved. But that important part trouble us today. Right. If one looks at 2 provisions, one in Schedule 3, one in Schedule 4, one sees the extent of the protection that the schedules give to provisions of this Act itself. So if one looks at MS 549, paragraph 42, any matter with which a provision of this Act falling within the following subparagraphs solely or mainly deals. Part 3, sections 19, 20, 28, 28A. So the 2 provisions at issue here are reserved matters. Over the page, one has...
Hold on. Well, strictly speaking, it's matters with which those provisions solely or mainly deal, which are reserved matters.
Yes. Now, of course, my Lord Reid anticipates, I suppose, the debate around whether the provisions are themselves reserved. We say firstly that they are. It's not necessary that they be, but it makes, we say respectfully, more sense if they are, because if the provisions themselves are not reserved, Schedule 3 is not itself a reserved or accepted matter. It would be possible to remove, to excise the provisions from Schedule 3.
But it's not saying that the sections are reserved matters. It's saying that matters which a provision of the Act falling within the subparagraph solely or mainly deals. There must be some significance in the use of the words any matter falling within the subparagraphs. In your argument, you don't even have to consider that.
Well, our argument's twofold. Firstly, it would be dangerous if the provisions themselves were not reserved, because if they're not reserved and if they're not accepted, then they are transferred, and they're simply subject to repeal, and that would seem to be inconsistent with the constitutional purpose. Secondly, if one accepts that there is a distinction between the provision and the matter with which they solely or mainly deal, a question perhaps more for the philosophers of language than lawyers, but if one accepts that distinction, then the question about what the provisions do, what is the meat of these provisions, is most certainly, we say, reserved, and a question about what effect they have, their extent, their reach, cannot but be, we say.
Well, if you imagine one of these provisions deals mainly with X, but also with Y, the effect of this is to reserve matter X, because that's a matter with which the provision mainly deals. It doesn't reserve matter Y, with which it deals but doesn't mainly deal. That perhaps illustrates the distinction.
Yes, I'm grateful, Lord, but if one looks, and I suppose that the nub of the argument of the interveners is, look, they say, look at the second part of paragraph 42. It doesn't apply to any matter to which a description specified in the schedule or Schedule 3 is stated not to apply. And look, they say, look at paragraph 1 in Schedule 2. That's at MS 526. And they say the functions of the First Minister and Deputy First Minister, the Northern Ireland ministers, all the Northern Ireland departments, are functions in relation to Northern Ireland of any Minister of the Crown. And they say, well, these are questions about ministerial function, and therefore they are not reserved. Now, we say that's misconceived. Again, it's important to bear in mind what is the primary purpose of these schedules. The purpose of these schedules is primarily to assist the Assembly, ministers and departments to understand what are the extent of their respective competences. It's not primarily drawn to assist with the definition of devolution issues, important plainly though that issue be. And there is no doubt but that the Assembly is free to place functions on ministers, to take functions from Minister A and give them to Minister B. There's no question but that is a transferred matter. Equally, we say the Assembly could not, at least not without the permission of the Secretary of State, amend or repeal Section 28A5 so as to reduce the nature of the obligation contained in that provision. Nor could the Assembly repeal or amend Section 28A10 so as to remove the loss of ministerial authority which that provision creates.
So you're putting forward these supposed practical difficulties in order to give meaning that doesn't appear textually from the provision.
No, but it does, my Lord, because if one asks the question...
It says any matter, not any section or any subsection.
Well, of course, Your Lordship has my first submission, of course, that the difficulty, the constitutional difficulty of exposing these provisions...
Well, I mean, that's one of the practical difficulties.
Well, but it exists in terms of the understanding of this.
Well, I think we have that point.
Is it to be thought? But the second point is the two matters are quite separate. Let's look at what Section 28A5 does. It imposes an obligation. It imposes a restriction when considered together with section 20 subsection 4. These matters, these significant or controversial matters, must be brought to the attention of the Executive Committee for discussion and agreement there. Minister, you're not free to deal with that issue yourself. And while the Assembly is free to, because it's a transferred matter, to give power to Minister A, to take it away from Minister B, it can't take away power from the Executive Committee. I mean, these are questions about the Executive Committee. That's the heading for section 20. And they're questions about the effect of the Ministerial Code. That's the heading of section 28A. And it's helpful to see which, and I'm using the term loosely, and I don't ignore the point that your lordships have made to me in exchange with respect to that the provisions, it is said, in exchange are not themselves reserved. But if one looks at paragraph 22 of Schedule 2, which is at MS 536, one sees 22 subparagraph B, part 3, except sections 19, 20, 22, 23, 2 to 4, 28, 28A, 28B, D, and E. And if one then flicks over to MS 549, so one has provisions that are accepted by virtue of paragraph 22. One then moves to paragraph 24 and one sees which ones are reserved. And a process of statutory arithmetic, one sees that there are a couple of provisions that are neither accepted by paragraph 22 nor reserved by paragraph 42 of Schedule 3. And they are, importantly for present purposes, they are section 22 and section 23, 2 to 4, subsection 2 to 4. And it will be interesting and important to look at those provisions. So if one turns to section 22, and that is at MS 394, statutory functions. An act of the Assembly or other enactment may confer functions on a minister, but not a junior minister or another Northern department by name. So again, the matter is made abundantly clear that dovetails neatly with the exception to paragraph 1 in Schedule 1. Similarly, if one on the same page, MS 394, looks at section 23, section 23, subsection 1 is an accepted matter. The executive power in Northern Ireland shall continue to be vested in Her Majesty. But subsections 23, subsection 2 to 4 are not accepted matters. See that from paragraph 22, MS 536, nor are they CF paragraph 42, MS 549. And we say that's highly significant because it makes it clear that the Assembly is free, these being transferred matters, to dispose of prerogative and executive powers, free to give functions on ministers or departments by name. But the provisions which have the effect of limiting the power of ministers are not transferred. They're accepted. Sorry, they are reserved. And understanding the extent of the break which they impose on ministers and departments is...
You have two major arguments still to deploy, Mr. Attorney, and 5 minutes left in which to do it.
Well, arising under this Act, we say that a question...
Paragraph 42.2 and the question of paragraph 34.
Yes. Well, very simply, my lords, arising under this Act, to attempt to understand what the effect of these provisions is, provisions in the Act arises to use the language of the Scottish provision by virtue of this Act, or using the language of the Act itself under this Act. It's a question of what this Act does. And that's quite different from a question, for example, an abstract question about did Mr. X validly receive a peerage? Because absent some concrete foundation, that can't be said to arise under this Act. It's an abstract question. These are not abstract questions. They arise by virtue of an effort to understand the nature of these provisions. And very simply in relation to paragraph 34. Paragraph 34, again, as this court held in Ashers, can be used even when the matter has been the subject of proceedings. And Ashers is a striking example because the abstract question was heard at the same time as proceedings that were actively ongoing in this very court. Rightly we say no issue was taken because the line was preserved. The questions I was asking were about issues that we needed to understand, arising also in that case by virtue of this Act. And again, very briefly in relation to the effect of the A5 case. The A5 case and the suggestion of partial overlap, we say, doesn't really bite materially for principally two reasons. The issue was not the subject of a devolution notice. The devolution notice that was issued related to the issue of compatibility with EU law, and indeed the applicants in A5 themselves contended and accepted that these devolution issues did not arise in that case. And we know now, of course, that case has come to an end. So if a harmonious reading is to be given to the various provisions in Schedule 10, it's our submission that a devolution issue, the possibility of raising a devolution issue under paragraph 34 is only barred if that issue has also arisen and been identified as having arisen pursuant to the obligation on courts and tribunals in paragraph 5 of Schedule 10. And it can't be sufficiently emphasised that these are not abstract questions about the coinage or the bestowal of a peerage. These are questions that matter. And this is a way in which Parliament has created for the most authoritative resolution of those questions by this court. And it is hoped that this court will in due course have occasion to answer those questions and to clarify these constitutional issues.
Do they continue to matter, notwithstanding the 2018?
Yes, because if the court has my submission that the 2018 Act is time limited. It falls away if once devolution is restored, but the court will see that the issues about...
Well, the issue disappears if devolution is restored.
No, it doesn't, my Lord, for this reason, because the issues raised in questions 3 and 4 about the programme for government are still very much live, because the court will have seen from the discussion that the Lord Chief Justice essentially reversed himself. He took the view previously, and we say he was right to do this, in Central Craigavon, that you couldn't be outside the Ministry of the Programme for Government if there was no programme for government. In Buick, he took the view that you could be outside the programme for government even if there wasn't one.
And if you're envisaging a world where there's no 2018 Act because it's become time limited, the time's expired, would you not have to look at the Cartona question in order to decide whether any of these issues actually arose? And if a Cartona objection is well-founded, is that not an end of the story?
Well, there can't be, there is no scope for the application of Cartona now because there are no ministers. So that issue simply falls away. But
when we say that, when you say it falls away,
well, the issue, the Cartona falls away. The issues don't fall away, my Lord. Cartona falls away because there are no ministers, and the doctrine depends upon A, the existence of a minister, and B, the discharge of a function by someone other than the minister.
But if at common law, civil servants can't exercise certain powers because only ministers can exercise those powers, or civil servants acting as the alter ego of a minister.
But well, I'm grateful, Lord, because actually your Lord's question enables me to state briefly a fundamental distinction in Northern Ireland constitutional law, that the transferred the prerogative and executive powers of the Crown are given to ministers and departments. Yeah. It's not the Scottish ministers.
No, I know, but the problem the problem didn't arise in relation to functions which were exercisable by civil servants, did they?
Well, they were, because Buick is an example of a case where a civil servant, the power to determine planning application is given to the department. And so the statutory responsibility may well be that of the department.
Well, whatever the right answer is that really the point of my question was: do we need to address a question which actually isn't a devolution issue before the devolution issue properly arises?
No, my Lord, we say not. These questions are themselves unmistakably devolution issues.
Well, in a sense, part of that whole thing was covered by the Advocate General.
Yes.
So.
Yes. Lady My Lords, I appear with Ms McLaughlin for the Advocate General, and I'm going to pass up a document which is a table which sets out the accepted, reserved and transferred provisions which we've been discussing just as an aid to following the structure of the Act. I've shared this with the other parties. Lady My Lords, the Advocate General supports the Attorney General's reference in these matters. I'll come to that table in a moment. The issues that are raised in this reference are, we say, not academic. They raise questions about the operation of the devolution scheme in Northern Ireland. The questions relating to Section 20 and Section 28A have already, even before the Buick litigation and even before the hiatus in government, given rise to extensive litigation in Northern Ireland. Paragraph 13 of our written case identifies a body of case law arising from the operation of these provisions. some of which involves one Northern Ireland department litigating against another, or one minister litigating against another on the basis that the other minister does not enjoy the power to act. So these are, generally speaking, issues that are live and important. However, the position in respect of the 2018 Act is, as the Attorney General has indicated, one which is time limited. That Act will provide a scheme that will operate until the 26th of March 2019, which will allow for civil servants to discharge some powers that otherwise would have been discharged by ministers. It's extendable once for a maximum period of 5 months. The ultimate sunset clause will occur in August 2019. If we do not have a restoration of devolved government in Northern Ireland by that date, then many of these issues will arise to the surface. If we do have a restoration of devolved government before that date, then the operation of Sections 20 and Section 28A will continue to raise these questions. And the interpretation placed upon those provisions by the Northern Ireland Court of Appeal will give rise to ongoing challenges. In particular, the question to which that case was directed, the extent to which matters must be brought to the Executive Committee for approval because they are cross-cutting, will be actively engaged. It is also, we say, and the Advocate General's interest in this case relates to the executive formation period, which is currently live. The Act, which was enacted in November, provides for a period of time, the purpose of which is to allow an executive to be formed in Northern Ireland by way as a result of the political negotiations. One of the issues that will have to be grappled with before there is a restoration is possibly how governance will operate with respect to Section 28A, the Ministerial Code, and Section 20, the Executive Committee. It's potentially an ingredient that must be resolved before we have a restoration of devolved government. And it's for that reason that the Advocate General, among others, supports the reference by the Attorney General to ensure that, if possible, this court can give any necessary guidance in order that the process of executive formation can proceed and any negotiations that are necessary can be conducted with an eye to a clear legal analysis of the import of these provisions. In the period available to me, I intend to address the 4 points raised by the intervener in their written case. The first point they raise is that the questions raised by the Attorney General are not about accepted or reserved matters. And I turn to the schematic table that I provided to the court. And what we've done there is set out the provisions that arise in Part 3 of the Northern Ireland Act 1998 and identified the matters that are arising and 3 columns. The Northern Ireland Act, unlike the Scotland Act or the Government of Wales Act, has 3 categories: accepted, reserved and transferred. In Wales and Scotland there are 2, reserved and transferred. The tripartite structure follows on from the Government of Ireland Act 1920, which was the first devolution statute, which introduced the concept of the accepted matter, and that pattern has been followed in Northern Ireland devolution statutes ever since. And what you'll see in the columns that we've put forward is that the significant majority of provisions in Part 3 of the Northern Ireland Act are accepted matters. And you will see that's by operation of Schedule 2, paragraph 22 of the Northern Ireland Act. So appointment of First Minister, ministerial offices, the executive, the disqualifying offices, departments and so on are all accepted matters under the scheme.
I'm finding this very puzzling because sections 20 and 28A seem to appear in both Schedule 2 and Schedule 3.
Yep. This
is an idiot question, I'm sure.
Yes.
Why is that?
It is confusing. They appear, they're referred to in Schedule 2, but they're referred to in a way that states that Schedule 2 doesn't apply. I think my lady's looking at paragraph 22.
I am.
Schedule 2. So they are not within Schedule 2, which means they must fall into either transferred, unless they appear somewhere else, or reserved. They appear, in fact, in paragraph 42 of Schedule 3.
They do indeed, yes.
Which means that they are therefore reserved. So there are two references to those provisions. And one of the reasons why we presented this table...
So it's 22 little Roman 2
Yes.
that says that because they're referred to in Schedule 3, they don't apply here, despite being there. Now,
Yes.
that's a very confusing way of doing anything, isn't it?
I wholeheartedly agree, my lady. And which is why we put together this grid in ease of the court, so that one can see readily at a glance where these various provisions actually fall. So only a small number of provisions and the matters that arise under them.
But why doesn't the same apply in reverse? Because paragraph 42 does the same.
Paragraph 42...
Paragraph 42(2).
Paragraph 42 operates on an inclusive basis, not an exclusive basis. So
Says it doesn't apply to
Yes.
any matter, or Schedule 2 is stated not to apply.
Yes.
Yes, I suppose so. Yep.
So it's
Yep.
inclusive.
It ends up there in the end.
Yes, a statutory Venn diagram
Penny has dropped.
is required ultimately. But one sees then the consequence of that is one has the lion's share of Part 3 provisions are accepted, therefore cannot be touched by the Northern Ireland Assembly. They are ring-fenced and protected. There are a small cohort of provisions which are reserved, and they include Section 20, Section 28A, Section 28 and 28B. So those are reserved matters. They can be, with the consent of the Secretary of State, the subject of action by the Northern Ireland Assembly, but otherwise are protected. And then one has, again, a very small number of provisions which raise matters that are transferred. So Section 22, Section 23, subsections 2 and 4, and then matters in relation to 28D and E. Those are transferred matters. Now, the case raised by the intervener is that the effect of the proviso to paragraph 42 of Schedule 3, you have that at MS 549 and 550, is to cancel out, in effect, the inclusion of sections 28, 28A and 28B. So their case essentially is, yes, those are described as reserved matters, but by operation of paragraph 1A of Schedule 2, that deliberate legislative act is immediately nullified, and that those matters are not, in fact, reserved matters. Therefore, they say the 5 questions raised by the Attorney General cannot fall within paragraph 42. We say that cannot be right. If it were the case, then Parliament would have legislated for an entirely nugatory purpose, and one bears in mind that 28A and 28B were all included by way of amendment to the original Act. And it would have been clear to Parliament, and certainly to those drafting the legislation, if the intervener's case was right, that this was a wholly pointless exercise. We say what in fact is protected by section paragraph 1A of Schedule 2, which appears at 526. That's MS 526. What is protected there is the Crown, succession to the Crown and the Regency, but not the exercise of functions by First Minister, Deputy First Minister, Northern Ireland ministers and departments. It is consistent with that Section 20 and Section 28A are considered to be reserved matters. And we say that because Sections 20 and Section 28A are not provisions which relate to the exercise of functions. They are provisions which impose procedural constraints and safeguards which prevent the exercise of ministerial authority if compliance with the ministerial code or presentation before the executive committee does not take place. So since they are not matters that relate to the exercise of functions, they are quite properly outside the carve-out that appears in paragraph 1A of Schedule 2.
In other words, you're saying that they're removed from the ambit of the exercise of ministerial power.
Yes, that's right. And on that reading, my lord, ladies, one has a consistent construction of these schedules to the Northern Ireland Act. That makes sense of paragraph 42, which gives, on one hand, section 28 and 28A as reserved matters, and then does not take away with the other by reference to the proviso. So, in our submission, it is by that method one achieves a coherent and consistent reading of paragraph 1A of Schedule 2. And it follows from that that these matters are properly to be considered reserved matters under the Act, and it follows that the Attorney and other law officers have capacity to bring a reference. Briefly then on the other points, I'll touch on those lightly because the Attorney General has touched on some of the ground. As I've already submitted, the issues that arise here are not academic. They may not be biting at present, but soon they will. These are questions of fundamental importance to both governance and the restoration of governance in Northern Ireland. But these are precisely the sorts of questions which we say paragraph 34 was intended to permit law officers to raise with the Supreme Court. Lord Mance touched on this in the Ashers case. I'll give the reference rather than go to it. It's paragraph 79 of his judgment, MS 1416 in this judgment, where there's a recognition that law officers may bring references of this type and can be relied upon not to engage or misuse or abuse that facility. And given the challenging circumstances that apply in devolution in Northern Ireland, we say this reference raises matters which the court ought to consider. Then it is said against us that paragraph 34 cannot be used to refer questions which arise in proceedings that are already disposed of. The Advocate General did not participate in the Buick litigation. That's a point that's taken against us. The Advocate General does not participate in response to every devolution notice that is issued to him, particularly where there's a governmental interest that is dealing with the matter, as there was in the Buick litigation. But there's nothing in paragraph 34 or in Order 120 of the Rules of Court which operates to exclude the Advocate General from bringing a reference either in his own right or in support of the Attorney General for Northern Ireland, even though he has not participated in lower tier proceedings.
Well, the argument against you is that paragraph 34 has to be read alongside paragraph 33, and that if the matter could have been challenged or raised, put before this court by way of a reference under paragraph 33, or indeed by way of an appeal by the attorney, this using paragraph 34 as a collateral way of challenging the conclusions reached in the Buick case, which the court shouldn't entertain. Yes.
Well, the Buick case could have been appealed but wasn't by the department for reasons that we don't need to explore, but that was the case. Nevertheless, the underlying issue identified in the devolution notice and accepted by the Northern Ireland Court of Appeal remains an issue, and notwithstanding the end of those proceedings, we say it's, bearing in mind that they are public law proceedings, these are not classically adversarial proceedings between private parties.
I think the burden of my Lord's question is, the Attorney General could have had recourse to paragraph 33 before proceedings were finalised, and he can't sit on his hands and allow the proceedings to be finalised and then have recourse belatedly to paragraph 34.
Well, his answer to that's a proper answer. At the time when that issue arose in August 2018, the Northern Ireland Court of Appeal had ruled that he couldn't do that. He was required to wait, and we were awaiting the judgment in the Ashers case. And only with the Ashers judgment did it become clear that it was open to the Attorney General to proceed, notwithstanding that the Northern Ireland Court of Appeal proceedings hadn't finished. So,
yes, but that doesn't really answer the question of why did he not exercise his power under paragraph 33 before the completion of the proceedings?
agreement, or it's not.
Well, it's not for you to answer.
It's not a complete answer.
No.
It is, we say, also significant that Parliament has reflected in the 2018 Act, in Section 3, subsection 8, the view that the findings of the Northern Ireland Court of Appeal in the Buick case may be open to doubt. One sees the way in which that provision is expressed. It's MS 859. No inference is to be drawn from subsections 1 to 7 as to whether or not a senior officer of a Northern Ireland Department would otherwise have been prevented from exercising departmental functions. In other words, Parliament has, in enacting that piece of legislation, appeared to have taken the view that there was some doubt about the ultimate analysis in respect of the Northern Ireland Court of Appeal's treatment of these issues in Buick. And we say that's another ingredient to add to the court's balancing exercise as to whether or not this is a matter that requires further consideration.
Well, I think you're out of time, and we do actually have to allow the contradictors some time to put the alternative case.
I'm grateful, I think I've probably covered most of the ground in any event, and you have our written case, which we adhere to.
You have indeed, yes. Thank you, Dr. Hopkins. Thank you.
My lady, you have the written case from myself and Mr. Honey, and we stand by that without repeating it. In the light of the oral submissions that have been made, could I just make three preliminary observations responding to that by way of context? The first point is, by way of context, the notion of references is a relatively unusual procedure within the common law. The normal position that this court is used to dealing with is a lis inter partes, a dispute. The second point is there is good reason why there is a reference procedure, because we are dealing with viries and the transfer of viries or powers from the United Kingdom to devolved government. And I believe Mr. Attorney put it in his submissions, we are looking at the extent of their regulatory competence. We'd endorse that and say the first point to stand back at is that when one comes to look at the Northern Ireland Act, there is a distinction between the allocation of viries or competence and, secondly, the manner of discharge of those powers. And what we're ultimately saying, amongst other things, is Mr. Attorney's references are essentially about the ways in which disputes that haven't even arisen, but that's another point, as to the discharge of those powers. And finally, as by way of preliminary observation, that we say that makes sense because, generally speaking, it's quintessentially more suitable for a court to have before it particular facts and circumstances when looking at the discharge of powers. One only has to take a step back and think of often judicial reviews, is the exercise of this discretionary power reasonable or proportionate. And those are things that inevitably depend upon their factual context. So we make those observations, and we say that that is what is at the guiding light when one reads what can be, in terms of drafting, complicated legislation. Briefly then, if we could deal, we've set out in our case in order of grounds, and if I could go to ground one, and it's set out at various places, but at MS 118 of our case, we quote from paragraph 42A. And with the greatest respect to both sets of submissions that we've heard, we respectfully submit there has been no proper answer to my Lord's question, paragraph 9, 118, to this. We must propose that Parliament had some intendment of including within section 42A the words any matter with which a provision of this Act falling within the following sub-paragraphs solely or mainly deals. And it's not just the word any matter as opposed to any provision, but also as clarified later in the text by solely or mainly. Two categories, as my Lord Reid put to Mr. Attorney. Parliament is intending there to be a distinction between a provision that may apply to certain matters but not to others. Now, if Mr. Attorney is correct, anything about any of the provisions would be included. And whilst I don't want to get into the even more academic areas of the evolution of peerages, even Mr. Attorney's example of a dispute about the award of a peerage could conceivably come within his own definition as a matter which is a provision, and rather than, as we say, one is looking at the discharge. So, quite simply, we respectfully submit there's been no answer to that point. What is said against us is that I think, Mr. Attorney, the constitutionally absurd situation where the Northern Ireland Assembly, he says, would have power to repeal the provisions listed in paragraph 42 of Schedule 3. I think, again, we need to take a step back. A section, perhaps, that hasn't been mentioned as much as it might is section 7.1, and may be useful just to go there, because (363) of Volume 1, my Lord and Lady. And that does provide for entrenching provisions. And that's important to understand the context of the submissions that we've heard from Mr. Attorney as to the ability or otherwise of the Assembly to repeal or amend other sections. Parliament has precisely applied its mind to entrenching certain provisions. And it's necessary, we say with respect, that if this argument is to be run by Mr. Attorney, that needs to be grappled with. And we say respectfully, it has not. But then, if properly understood, when one comes to, for example, section 28A, 401 of the Ministerial Code, there are plenty of aspects of it, of section 28A, which are dealing with the discharge of the functions. And indeed, we would say applying the Ministerial Code is an example of something that relates to the exercise of those functions. The transfer is giving to the devolved government in whatever way, whether it's to ministers, departments, powers, whether it's sewage powers, rights to ennoble people, or what have you. The Ministerial Code is a way that appertains to how you would exercise that function. It doesn't give you a new function. It doesn't say, oh, you've got defence powers now, or you've got environmental powers, or new functions. It relates to how that function is to be exercised. And we do pause to observe that whilst the prospect in Northern Ireland of new government and sensible and evolving government, people may have views upon as matters presently stand. But it must be hoped that in the future that the Assembly may, at appropriate times, look to amend, or in certain cases, repeal certain matters which are within its jurisdiction. And Parliament, of course, always retains power to recover anything if things go amiss. So it's important we submit not to be to go beyond the text and the way in which this text was crafted to serve that fundamental function. And we just pausing to observe, I think the submissions made by my learned friend on behalf of the Advocate General, we would respectfully submit it's no part of this court to start giving guidance to politicians on forming a new executive or to the civil servants, as appeared to be suggested. So on ground one, we do say the position is quite simple. A devolution issue can arise in respect of a matter, and that the Act is pretty clear in setting out that scope. So unless we can assist anything further, my Lord, I'm conscious of the time, I'll go on to ground two, because we say it doesn't arise under this Act in any event. And it's useful to go back and look at the Mr. Attorney's questions. And could your Lordships bear in mind, helpfully, Mr. Attorney has produced a grounding affidavit from a civil servant. I won't take your Ladyship and Lordships to, which sets out the background for this reference being made. Could I ask you, when looking at that affidavit, to note this point? It doesn't refer to any issue having been raised by any civil servant in respect of any of the questions which Mr. Attorney seeks reference. These are entirely questions from the mind of the Mr. Attorney. I don't mean that in a derogatory sense. They are from him, and he made it very clear. These were concerns that he had with the Court of Appeal judgment. But what is missing is any evidence that these are matters actually arising at the moment. And we do say, and take issue with the way in which my learned friend put the case for the Attorney General, which seemed to be suggesting issues that might arise in the future. So this is not a case where, even though the issue has not come before the courts, the civil servants' evidence is before this court of particular issues arising which are troubling the court. And for various reasons, we can only go on the evidence that is before the court. So it's an entirely academic issue. And the word arising, we say, means, again, what it says. So to use an example, we say it wouldn't be sensible to say that a question was arising under a contract if the question simply came about because of one party's desire to elicit a better understanding, as Mr. Attorney seeks in this case. That's not an issue arising. And so the question doesn't arise. You could have a contract that deals with many things. It deals with the circumstances, perhaps, of a house catching fire. The house has never caught fire, but it's been burgled. So you apply for reference to understand what the contractual provisions relating to the house catching fire. That is not an issue arising under the terms of the contract. And it is important that this court isn't used even to usurp the role of Mr. Attorney. Mr. Attorney has the role, I understand, when departments come to him, although he's not part of the government, to advise from time to time on, no doubt, theoretical points of law that may be troubling them. But that is not, we respectfully say, the role of this court. And indeed, the word dangerous has been used, but I think, learned friend for the Advocate General, we would say it's highly dangerous for this court to be asked to pontificate on matters that aren't arising. The next ground we wish to go to is the issue ground 3 of which relates to paragraph 34 and whether the proceedings have been disposed of, and the subject of the last interchange between the court and Mr. McGleekin for the Advocate General. The first point, we make a number of observations just as matters of fact. First of all, we come here on behalf of third-party local residents. It's not our role, with due respect, particularly when you have the combined talents of Mr. Attorney and the Department of the Advocate General, for us to supply this court with the full details, if we could get them, of what arose in Buick and what has arisen in the 4 other cases that are listed helpfully in the Annex 1 to the written submissions on behalf of the Advocate General. But we do say, in the light of the way in which this matter has arisen, this court has raised the question of jurisdiction. It is for Mr. Attorney to go through each of the heads of the jurisdiction, particularly when they're in issue, and to satisfy this court that jurisdiction is met. We don't accept that in respect of those cases that we can assist you, the A5, and as it happens, I also happen to be counsel in the Loughney case, along with a number of my learned friends here, but in the A5 case, it isn't the case that the issue of to which this reference relates was not raised, and
that case has been disposed of because Mr. Justice McCluskey heard that the department didn't wish to maintain its defence of the judicial review application.
Exactly, my lord, that's right. And the department, having applied, and Mr. McGeekin was acting for the department, for the matter to be adjourned on the basis that we would await the outcome of this reference. So far as the position of the Attorney General in the Buick case, we rely on what we say at paragraph 30, which we don't believe is in dispute, at 127. The Attorney General was perfectly entitled to have appealed that judgment or to have made a reference under paragraph 33, as my Lord Kerr put to Mr. McGleekin. And
I think Mr. McGleenan's answer was that, be that as it may, it's now clear from the judgment of Lord Mance at paragraph 79 of the Asher's case that it is open to the attorney to have recourse to paragraph 34, notwithstanding his failure to apply timiously under paragraph 33.
Well, my Lord, I think one needs to look at the jurisdiction in the particular circumstances of the case. There's no suggestion by Mr. Attorney that he was not seized of the issue or the point. And no explanation has been given, unless I've missed it, by Mr. Attorney as to why he didn't either appeal, which he could have done, or indeed exercise the powers under paragraph 33. And we do raise in our case, I mean, we happen to be here, but it's quite likely that this matter would have come before your lordship with no countervening.
Well, just on that point, could I ask you, if we're here convened to address a preliminary issue
Yes.
as to whether or not these can qualify as a devolution issues
Yes.
at all. If we were to decide, I mean, there are various options. Either we decide that they do qualify as devolution issues, or we decide that they don't, or we may decide that it's not appropriate to deal with them by way of preliminary issue, that they require further examination. In that event, should we understand that you would not necessarily be a legitimate contradictor on a full hearing?
In our submission, as I understand the position, notwithstanding the Act and the time, there's a time limit of the 2018 Act, and certainly we've already made submissions to the Secretary of State that a public inquiry would be necessary in order to reopen the A5 orders. We also have made very clear that we don't believe that the Act, when properly understood with the guidance that's been provided, would cover controversial and substantial developments such as the dualling as proposed for the A5. So we would be taking issue with any reliance that would be taken by a permanent secretary exercising purported power under the Act. So I think the answer to the question is we'd still maintain that we have an interest in any proceedings going forward.
Well, there's been no objection taken to your stand.
For which I'm grateful. The only issue I do raise, we're here pro bono, and there is a limit in any event for those. I mean, we explain the importance, obviously, to our clients of marshalling funds for other days and other battles. But no decision has been made. But in terms of whether we'd have an interest or not, my submission is that we would. We just, if I could give to your to the court, because it's a point that was raised against us, that, and I'll come to it when I come on briefly to ground 4, but just flag up, I'll give the court the references in respect of how we say the issue was flagged up in our originating motion, but that's really a ground 4 point. We do say that the court should be slow, and whilst we don't suggest make it very clear, any bad faith, but just institutionally, there are problems that arise in the way in which this matter has come before the court. There is no representation from Buick, and one has to be a little bit careful because it's been submitted to this court that the 2018 Act, when it says no inference is to be drawn, that this court should take an inference that Parliament thinks that the Court of Appeal got it wrong. Make it very clear that Parliament says what it says and no inference can be taken. And indeed, we would submit this highlights one of our points, that coming by a reference procedure rather than an appeal procedure, and then suggesting a Court of Appeal decision, which neither the Attorney, the Advocate General, or the Department appealed, is wrong, is something that we respectfully submit should not be encouraged by way of a process. The other point, of course, is in respect of the submissions that have been made by Buick, and it may have been a slip by Mr. Attorney, but he suggested that the Department were successful in some respects of the appeal. The position of the Court of Appeal in Buick, so I think my Lord Reid indicated, is that the Court of Appeal confined itself in terms of the ratio of the case to one particular aspect of cross-cutting, didn't then express the other views that were expressed by the majority and then by Lord Justice Tracy as a minority were obiter, and that is the position adopted by the Department in our proceedings, and one has the note produced, which is at MS 75 and 76, on behalf of counsel for the Department. So who now appears on behalf of the Advocate General. So the position of Buick, far from, we respectfully say, having been one where Parliament has said the Court of Appeal were wrong, Mrs. Justice Keegan's decision remains extant. The Court of Appeal has not overruled it in other matters, has found upheld it, and then expressed different obiter views in other matters. So, as it happens, the factual background, we say, reinforces the need to adhere quite closely to the protections given by Section 33 and 34, and they shouldn't be the appellate process shouldn't be sidestepped in the manner in which it has been. It does inevitably mean that the party that has been involved will very often not be there. They've got their judgment, they've got their costs, and in that case, I think, again, it was a challenge by a residents' action group. Many will not want to pay for the pleasure of coming before this court to argue these important issues for understandable reasons. So we do ask the court, notwithstanding what may have been said elsewhere, to be very astute, to guard what we say is the proper way and the proper function of the reference procedure. Turning finally, if I may, to ground 4, and that's an issue as to whether the matters were subject of proceedings. And of course, when one looks at, 34 of yes. The ground 4, the matters were subject to the proceedings. At the time the reference was made, the A5 proceedings were still ongoing. That has, and this court has been informed, but the trigger date is the date on, we say, on which the reference is made. And insofar as the issue having been raised, and I said I would come to it, just for you, I don't ask the court to turn it up, but in the notice of originating motion, MS 68 and also MS 79 and 80, sorry, MS 248 and 251. Let's go to it so I've got the right ones. Yeah. 248, paragraph 14, relates to what happened at the inquiry. And 23 goes on, where the advocate, Mr. Macmillan, Queen's Counsel for the department, made clear the decision would be taken by the Minister. Paragraph 23 of the originating motion, the decision in the case, this is at MS 249, was taken not by a Minister and not with the consent of the Executive, by a civil servant, Peter May. And then at the bottom of paragraph 24 then goes on to deal with Article 4.1, and then Section 17.3 of the 1990 Act, and then says this reflected the statements made by the Attorney General in court on the 22nd of November 2016, which were relied on by Mrs. Justice Keegan in her judgment on leave and by Mr. Macmillan at the inquiry. The decision could not lawfully have been taken than or by direction at the time of the relevant minister. And then it continues at 25 and 26. We make the point that under Section 20, the Executive has the function of discussing and agreeing issues upon which cross-cutting And the decision at 26 was cross-cutting within the meaning of subparagraph 5 and also significant and controversial subparagraph 4. And there was no current agreed programme for government. By way of background, not that your lordships need to be other than aware of it, there have in fact been 3 A5 judicial review proceedings brought by my clients. The first one resulted in the first quashing of the order. The second one, which is still in limbo, partly, which relates to the absence of a programme of government. And the third one, which was compromised in the way that your lordships have seen. And then the last reference on this is just 251, paragraphs 33 and 34. So I just take your lordships to that, and perhaps also MS 68. And the last paragraph there, it's letter from the department beginning, I respectfully submit that the Supreme Court answers to each of the 5 questions will be relevant to some of the issues raised by the applicant in the case. This is the department's solicitor. Namely those raised in paragraphs 33 and 34 of the applicant's notice of originating motion, and then referring to the detailed submissions in our skeleton argument. And it's clear that the constitutional issue is essential to the case advised by the applicant. It follows the High Court will be invited to give judgment upon issues directly within the scope of the Attorney General's reference. Those circumstances submitted to the Court should await the judgment of the Supreme Court on the reference before the statutory challenge. And therefore, that was the application by Mr. Brown for the Department for the adjournment of our ongoing judicial review pending the outcome of the Supreme Court's reference. And we opposed that, but Mrs. Justice Keegan nonetheless granted the adjournment. So we just go to those points because it still appears to be being pursued before this court that the matters were the subject of proceedings. We also have in Annex 1...
But I'm sorry, got to be clear I've understood. So the issues, at least some of the issues we're being asked to look at in the reference, are actually live in your JR, and that's been stayed to await the outcome of...
My Lord, no.
Oh, I've got that wrong, have I?
It's my fault, my Lord. What happened was the department said that the Attorney General's reference raised issues that could be determinative in the way in which the letter is set out.
I see.
We said, consistent with the submissions we're making here now, well, whatever the reference is, the case should go ahead, but nonetheless it was adjourned. It was adjourned, and then we had a mention hearing scheduled, which my instructing solicitor was to attend, and the night before that mention hearing, to see how we received a letter, I think it was on a Thursday at 5 o'clock, from the department indicating they were consenting to judgment on the ground that the decision had been taken by the permanent secretary.
Oh, I see. So this particular JR is one of the ones that's now completed?
That's been completed. This is a JR in which we're involved in, which was completed following our intervention. So we intervened in these proceedings, and the case was due for mention because it had been adjourned, but with a mention date to come back to see what the position was. And I think it's around about 5 o'clock or just after 5 o'clock, those instructing me received, without warning, it must be said, a letter saying that the department was consenting to judgment on those grounds.
But does that relate to the letter from Mr. Brown?
Yes, Mr. Brown had previously,
So
obtained,
this letter has been overtaken then?
Yes.
I see.
But what was said was that the adjournment was obtained on the basis that we'd raised these issues, and they were. This is the department's case, directly impacting on these references. We're now told that our case didn't raise them. That's why I'm taking your lordship to it. We said we wanted to carry on, And they said, no, you can't, because of the Attorney General's reference. Now we're here and we're told our case doesn't raise any of the issues.
But in any event, Mrs. Justice Keegan, and indeed no other member of the High Court in Northern Ireland, will have the opportunity to address these issues.
No. Because,
Unless there's another...
yes, unless another decision's been made, because an order was made without opposition by us on terms suggested by the department, in which they consented to judgment on the grounds that the decision was taken by the Permanent Secretary, and that was it. Of course, there is, and your Lordships will see in the annex to the Attorney General's case, the so-called interconnector case, where we understand, but we're not involved in it, and we only have what kindly has been provided by, on behalf of the Attorney General, the details of the interconnector case. In Buick, your Lordships will, and Ladyship will see that counsel for the interconnector was granted leave as a notice party to intervene in Buick and make submissions. So it's clear and those proceedings are ongoing and have been stayed. We're not party to them, but those are ongoing.
That's the interconnector proceedings.
The interconnector proceedings. And
so they're stayed, well, we're told in the appendix to the Advocate General's submissions that those proceedings are presently stayed pending this reference.
That is right.
So presumably the issues raised in reference are also issues that are relevant in those proceedings.
One can assume. I mean, the difficulty is, of course, the position of the stay of the proceedings is that hitherto the department has been saying this reference impacts. I can only speak for the A5. Impacts on your case, and it should be stayed. And so the courts are staying these proceedings. As I said, there may be more. I don't know. We've only got the ones of the Advocate General. Whether or not that's a proper course is another matter. But that is the position. And obviously I'm not counsel involved in those proceedings. So para 34 would bite in relation to those proceedings in any event.
That's about para 33.
And para 33, yes. So para 33. And again, we have no explanation put forward. I mean, even the Advocate General now has had a good chance to appreciate the importance of it and can pile into the interconnector case or the other. There's some other cases. I'm not inviting you into the Loch Ney case as well, but be more than welcome.
It seems very odd that the parties who actually have an interest are being asked to wait until for the outcome of proceedings in which they are not taking part.
Well, my Lord, we would respectfully say yes. And that is why we say these questions, for all the reasons we've submitted, but they all actually hang together. And this is why we do say, well, this court's got to be very, very slow, with all due respect to Mr. Attorney and one of the most distinguished lawyers of the Northern Ireland Bar, and if not England and Wales. But that isn't the purpose. Creative lawyers can come up with all sorts of issues that may be troubling, and life would be much easier if we could, on tricky opinions, come to this court. But the problem is, and it is a problem, all these cases are being held up. And then there's an inconsistent approach, it appears, as to those that are being compromised without any clear explanation, frankly. And we do say, we are trying to assist this court as best we can, but as my Lord Reid says, it would be much better if we actually had the parties who are involved before the court. And we were a party involved, but then we got the consent judgment. But my lords and lady, I've reached my time, and and subject to any questions, I think we've endeavoured to set out our case as clearly as we could.
Well, you have set it out very clearly and very fully. You haven't actually reached your time. You've got another 5 minutes, should you wish to employ it. I'm not encouraging you to, but you do have them.
When has an advocate never taken up the opportunity? I think this may be that opportunity. I've turned to Mr. Honey, who will always have a point better than me, and he hasn't suggested there's another one. So I'll sit down unless there's any questions the court has.
No, thank you very much indeed, Mr. Jones. Mr. Honey, do you have anything to say? Thank you. Mr. Attorney.
Lady and Lords, 4 points very briefly. Can I ask the court to look at the notice in Buick? It's the second devolution notice. It's at MS 210, and if one looks at that in connection with the respondent's notice, which is at 207, 2A, this actually bears out what my learned friend Mr. Jones said, that essentially the ratio of Buick is in relation to cross-cutting. Everything else is obiter, and the devolution notice it raises because it's arising from the respondent's notice, raises the cross-cutting issue. Of course, that doesn't represent, even if it mattered, anything like a complete overlap with the 5 questions here. Secondly, the A5 notice for the court's note is at MS 259 running to 262, and one will see at 260 that the issue there, the only issue identified as a devolution notice, is that of compliance with EU law.
Well, we say that, but Mr. Brown's letter made it clear that the answers to all 5 questions apparently were relevant to that case, which was why it was being stayed.
Well, Mr. Brown didn't write on my behalf, and of course, when that...
No, but he was a party to the proceedings.
Oh, well, he was, but I had the opportunity on receipt of that devolution notice, but decided not to intervene because the matter would be more than superbly addressed by counsel on behalf of the department. It didn't give rise to a particular issue of Northern Ireland constitutional law. So that was the only devolution issue that arose in A5. Now, as for the actual originating notice, the closest that one comes to anything which in substance amounts to an overlap with these issues is at paragraphs 33 and 34, because the passages in the originating notice that my learned friend took the court to were actually by way of background. These are in fact grounds. So at MS 251, paragraphs 33 and 34, one sees a decision taken in breach of a binding legitimate expectation. Well, these questions are nothing about binding legitimate expectation. And the decision was unlawful, taken by a civil servant who was not at all times subject to the direction and control of a minister. And that is the Article 4 of the department's order point, which again, we entirely accept that's not a devolution issue. That's entirely about a transferred matter. That's not referred. And although the matter isn't placed beyond argument in this way, nonetheless, it's interesting to see what the interveners themselves say on this issue. And one finds that at MS 83, MS 84, paragraph 5, MS 83, questions 1, 2 and 4 in the Attorney General's reference to the Supreme Court plainly do not raise issues which overlap with the instant application. 6, as to question 3, the Department has not said in the instant case that the Act didn't apply on the basis there was no programme for government. That was not part of the reasoning relied upon by the Department for taking the decision, as explained in Mr May's affidavit. 7, question 5 is premised on the effect of Section 28A5, which is not a provision relied on by the applicant. So the applicant doesn't rely on Section 28A5. That's their case. They know it better than anyone. And then questions 3 and 5 are at most of indirect relevance to the instant application. I'm happy to proceed with that as accurate. That's not...
Well, who knows? These things tend to be organic, as you know, Mr Attorney.
Well, they do, and I accept that.
And it may well be that all of the issues that are raised in your questions could become relevant in any manner or any number of litigation episodes.
Well, happily we know it can't happen with A5 because that's come to an end. Reference has been made to the interconnector case. No devolution notice has been served on me in relation to the interconnector case. And that's why I did draw attention to paragraph 5.
But it apparently has been adjourned pending the outcome of this case.
No notice has been served. And my lady, my lords, let me be as clear as I can be. Plainly, if a devolution issue has been identified, I can't refer that devolution issue under paragraph 34. That's if a devolution issue has been identified in proceedings and a notice served on me, I can't identify that same issue in paragraph 34 proceedings.
No, but you can participate in the proceedings in which
I can.
The courts of Northern Ireland address these questions.
Indeed, but no such notice has been served in the interconnector case, and we've seen the notice that was served in the A5 case, and it didn't raise anything like these issues.
Well, you're not. What you refer isn't defined by the devolution notice, which is part of the internal procedure of the Northern Irish courts. And that's simply a mechanism which gives you notice and enables you to take part in the proceedings.
That's so.
But it doesn't circumscribe what you might thereafter decide you wanted to refer under paragraph 33.
Well, but the issue would nonetheless have to be, if I get involved in the litigation, and the portal will typically be the service of a proper notice. Obviously, if the notice doesn't identify issues which in fact are perhaps lurk below the surface in the litigation, well, I have no opportunity of properly participating because I'll see issue A, that's not of interest. I don't become a party, and whether or not other issues remain below the surface won't matter because I won't be involved in those proceedings.
But say in the interconnector case, it might be thought that things have got the wrong way round. If that case has been stayed before any devolution notice had been served on you, in order to await the outcome of these proceedings, which aren't going to involve the participation of the very people whose interests are going to be affected.
Well, of course they could, because obviously one knows that the substantive hearing, obviously the parties, with the exception of the Public Spirited Council for the A5 Alliance, may not get involved in what may appear a rather technical procedural question, but I'm quite sure, knowing my colleagues as I do, that when the substance of this case is explored, those who have an interest on behalf of clients will apply to intervene.
Well, you say it's a technical question. I mean, it could be determinative of the success of the interconnector case, couldn't it?
Well, I'm talking about whether these are devolution issues. I simply don't know.
I mean, you can identify devolution issues even though you haven't been served a notice of a devolution issue, can't you?
No, my lord, I rather apprehend not, and it is for the court and the parties, shall we say the pre-existing parties, to identify the issue. The notice is served. That's the interplay between paragraphs 5 and 6 in Schedule 10. It's as a result of that. Now, I have historically.
That's what I was going to say. I'm pretty sure you have in the past.
And I said, are these not devolution issues? But it hasn't always elicited a positive response in terms of, welcome response, but in terms of eliciting a notice pursuant to paragraph 5.
Well, absent a notice, if a judgment is given and you can, from your perusal of the judgment, identify what you consider to be devolution issues, surely you can then have recourse to your powers under paragraph 34.
No, regrettably no, my lord, because the exercise of the Schedule 10 power is conditioned on having been already a party.
Yes.
Could you apply to become a party?
Well, that's a possibility, of course. That raises the issue which was usefully explored in Asher's of proceedings between delivery of judgment
Yes.
and drawing up of the order.
Yeah. Yes, I mean that's the case where, in particular circumstances, there was no abuse in using paragraph 34 because the application under paragraph 33 had been refused by the court. There had been an attempt to use paragraph 33, but it had been blocked. But here, paragraph 34 makes it clear that it's not to be used where the devolution issue is the subject of proceedings. Now, you take your stand on the fact that, well, that hasn't happened yet. Well, of course it hasn't happened yet because the proceedings are stayed. It's not going to happen so long as they remain stayed. But the reality, one might have thought that what's happened is contrary to the intention implicit in paragraph 34, that where there are proceedings in which the issue could be raised and referred, that's the appropriate way of doing it.
Well, in general terms, of course, I entirely agree with that, and let me be again as clear as I can be, that if a devolution issue had been drawn to my attention, I wouldn't have made a reference under paragraph 34. But back to paragraph 33, I will say, of course, that in paragraph 33, it would have probably required greater intestinal fortitude than I myself perhaps regrettably possess to have gone to the Court of Appeal and said, look, I know what you've decided in Asher's. I thought the appeal in Asher's went rather well. Here is my paragraph 33 notice. Obviously, it is respectful of the hierarchy of courts to abide the formal decision of this court, which is the course that we took. The attitude that a court might take now that one knows the position in Asher's in relation to a case where a law officer has intervened and doesn't take the point now that the matter has been put beyond argument, it may well be different. Two very, very quick points in relation to the characterisation by Mr. Jones of what we're dealing with. We are not dealing with the discharge of functions, we are dealing with the manner of the discharge of functions, and we are dealing with restrictions on the discharge of functions. The Ministerial Code and the new responsibility of the executive created by subsection 4 of section 20 is a constitutional step that was necessarily taken to avoid an earlier hiatus in devolved government. And the question really is not so much about can Minister A do something, but what are the limits imposed by the executive machinery and by the Ministerial Code on the Minister as respects the programme for government, but also importantly in our present hiatus in relation to the departments. And my learned friend's answer to our point, well, if he's right, it means that the provisions adumbrated in paragraph 42, and for that matter in paragraph 22 of Schedule 2, could simply be repealed, is to essentially say, well, yes, that's the choice of Parliament because these provisions are not provisions that can't be modified pursuant to Section 7. And of course he's right, they are provisions that can't be modified, but mindful of the very recent decision of this court in the Scottish Brexit Bill, of course, which turned in large measure on the distinction between protection against modification and reserved matters in that case. That ignores the fact that Parliament has intended to create these restrictive categories, absolute in the case of accepted, less than absolute in the case of reserved, and that the characterisation by my learned friend simply dispenses with those at a stroke and enables the Assembly to get rid of them. That say, simply cannot be right. Finally, what he says, my learned friend's characterisation of the words arising under this Act, which we say is synonymous for all practical purposes with by virtue of this Act in relation to paragraph 1G of Schedule 6 of the Scotland Act is, he said, it's not arising at the moment. But that's not the test. We say, in fact, it is. If one looks at paragraph 4 of Ms. Duffy's affidavit, MS 151, we'll see the practical necessity of this set out. No one has taken issue with that. But the issue is not, even if that were not true, the issue is not, does this arise at the moment, but does it arise under this Act? And we say that understanding what these provisions mean, these provisions in the Northern Ireland Act mean, can only rationally be said to arise under this Act. It's not about, did Mr. X rightly get a peerage? That doesn't arise under this Act. It's maybe an interesting question, but it can't be said that although it deals with an accepted matter, couldn't remotely, on any characterisation, be said to come within the proper scope of paragraph 1D. My lady, my lords, unless anything arises, those are my submissions.
No. I think not. Thank you very much indeed, Mr. Attorney. Well, we will now go away and try and work out what the answer is. Thank you all very much indeed for your attendance and for your submissions, all of you.